witness is still under oath. I delayed for a further 5 minutes as I had a request that there were persons that first had to console themselves and get ready. I thought it was appropriate to do that. Thank you, Mr. Harmse. Do you have any questions to the witness?
I do.
Ms. Nkabai? Thank you. Ms. Sivnarine? Thank you. You have an easy ride?
Indeed, my lord.
And again, thank you for your assistance. I know that you're part of a team sitting over there. You may take your seat.
Thank you, my lord.
Yes, Mr. Harms. That's all the evidence I take.
Indeed, that is correct, my lord. That is all the evidence for the
Good.
stand.
Thank you.
My lord, may I please ask that we swap around? Ms. Swanepoel will be dealing with the arguments.
Certainly. I'm going to start immediately with Mr. Harms. Then we're going to go through the defense, and then the state will have the opportunity.
Certainly, thank you.
Yes, thank you, Mr. Adamson. Thank you.
May it please the court, my lord. I think it's on record as well already that accused one will not be giving evidence on the mitigation of sentence.
But having said that, it's customary that submissions and information, insofar as it relates to evidence, can be placed on record from the bar.
Indeed, my lord, yes.
And I was contemplating that question last night. In the event that the witness on behalf of Mr. Van Rijn might not be available, that Mr. Kabai can place the information on record from the bar, whatever further information
Indeed, my
is
lord.
placed. As you know, it's customary that the three options are given, and it happens every day. I was going to refer to an old story of the Cape High Court, referring to a former colleague of mine, but then I realized that the colleague might still be alive. The colleague would be 98 years old now, and we turned 99 on my birthday because we share a birthday. And it was also the day that Shupi was delivered, on that day. So I decided not to
I
tell
take
the
note.
story.
I take note, my lord.
But I think you know the story.
Yes, my lord, I am aware of that, yes, my lord.
Yes.
Thank you, my lord. I'd like to start off with accused one's personal circumstances. I have, in the circumstances, much less to say on the court having been placed in possession of Exhibit SS. I have looked at the details as far as the personal circumstances of accused one, or let me refer to Mr. Pollis. Mr. Pollis's personal details, his age, where he comes from, his family, his brothers and sisters and children, it's all in front of the court. With the leave of the court, I'm not going to repeat all that.
It's on record, and I've taken note of it.
Yes, and may I then, just for the sake of completeness, then refer to what was referred to when Mr. Peterson gave evidence that there are one or two inconsistencies, but the court is well aware of the evidence that was led in this matter, and it is, as Your Lordship had said, of no moment, the aspect around Joshlin, whether she was at school or not at school, and what my Mr. Pollis would have said to Mr. Peterson or not. I agree that it's not going to make, in the circumstances, any difference to argue that he isn't or wasn't lying to Mr. Peterson. That I'm not going to argue.
Is the question not, and it relates more to count one, because of the existence of the prescribed sentence, that I need to focus, and yes, I need to focus on it holistically. Was it you that referred me to Malchus?
No, my Lord.
I've got a number of cases open here. I've got...
The state referred, Your Lordship, to Malchus. I didn't, because they did.
Yeah. So we need to look at substantial and compelling circumstances.
Yes, indeed.
And yes, we need to look at it holistically. It's not nitpicking one here or the other, but there's also the authorities from the Supreme Court of Appeal, and I've been referred to a case, whether it's on point or not, that I'll debate with Ms. Kabai from the Constitutional Court, where it's also dealt with. And the question is, how do I approach the substantial and compelling circumstances, and how do I weigh that with the general principles? I see people are still referring me to Zin and Rabi, and we can debate that. In coming to a sentence that is just, it's coincidentally also a term used by Mr. Peterson in his evidence yesterday, because that's the bottom line here. What is fair and just, having regard to, if one wants to refer to the triad, if you want to refer to the element of mercy, a la Rabi, depending on how you interpret Rabi, because the textbooks seem to only refer to the one of the judgments, whilst we know, I don't know whether people know that there were actually 3 judgments in that case, and nobody ever refers to the facts of that case, because the facts are very peculiar. And it's not necessarily set out in the judgment that's often referred to, because I get referred to the judgment of Corbett, that last paragraph, the Corbett J.A. as he then was, and ignore the judgments of Kotze A.J.A. and Holmes J.A. as they then were at the time. That's a 1975 judgment.
Yes, my Lord.
So I don't want to unnecessarily stop you in your tracks, but if you can address me on having regard to the personal circumstances, the circumstances of the offence itself, circumstances that prevailed in which the accused had operated at the time, seriousness of the offence, the interest of society, the purposes of sentence, coupled with that all of this is infused with a measure of mercy, and that I must bear in mind that I'm not here to take revenge. It must be balanced. It must be focused on the individuals, human beings that are being sentenced before me, having regard to all these other factors.
Thank you, my Lord. Yes, my Lord, if I may, because I find it very important and it should actually be argued at the end, I want to open with it and hopefully I'll remember at the end.
Can I just ask that there maybe adjust the microphone for you? You're competing with the wind and the shutters in the roof. And I'm not sure whether people are able to hear you properly.
Ja, ik moet eens ook gaan kijken.
Yes, thank you.
My Lord, yes, what I did refer your Lordship to, and I see my learned colleague for the state has also done that, was the matter of state versus Habib.
Yeah, that's the judgment of Kurtze.
Kurtze AJ. Kurtze CJ AJ, yes, my Lord.
Yeah,
CJ, I don't know why they put that there, my Lord.
I don't know why it's cited like that, but it is so.
Maybe they have another Kurtze there, my Lord.
We used to do that in the Cape because we had more than one Erasmus.
Yes, my Lord. And then I also referred your Lordship to the state versus Edward Ayuk, which is the Western Cape High Court
Yes, that's the judgment of
the VED.
Of the VED
AJ, yes, my Lord. Yes.
I've read both cases, and I have an opinion.
I'm sure your Lordship will. I'm not going to submit that there's anything prescriptive in there. It is, as far as the big matter is concerned, I liked, if I can use that word, the method that CJ, acting judge, used in that matter.
Yeah, I'm with you.
What I wanted to mention at the outset, my Lord, is the Prevention of Combating and Trafficking in Persons Act, Section 13. So I know I'm starting at the back now, my Lord, but I just want to place that before your Lordship, first of all, and I'm just going to read paragraph 13A, where it says Section 4.1 is subject to Section 51 of the Criminal Law Amendment Act 1997, in brackets Act number 105 of 1997, liable to a fine not exceeding 100 million or imprisonment, and then, comma, including imprisonment for life, comma, or such imprisonment without the option of a fine. Now, what I would like to argue at the end is that how I see it respectfully, with humility, humbly will argue that maybe that has some significance, the fact that it says including imprisonment for life. I'm in agreement with my learned colleagues for the state that, which has been said before, that this is a unique case. This matter that we are seized with is a unique case in the sense that the victim is not here. We do not know where the victim, Joshlin, is, or what happened to Joshlin. So the court had to rely on all the witnesses, the evidence that was placed before this court. And yes, indeed, the court has found Mr. Apollos guilty in terms of section 4.1 in count 1, and then obviously count 2, kidnapping. Now the difficulty that I submit we're sitting with is that we don't have before the court any explanation as to what happened on the 19th of February 2024. We only have the evidence that was led, and the Lordship has admitted the extracurrial statement of Mr. Apollos, where a version of what happened was accepted by this court as a possible or probable version, in the sense as the evidence that led from the extracurrial statement by Mr. Apollos, that there was a discussion between himself and accused 3, that he had walked with Joshlin to Makalima's house. And that being so, then being accepted by this court, that is one of the grounds upon which he was then
Let's work with
convicted.
Let's work with it. He was in fact in loco parentis of the child on that day, Josh, but also broadly could be described as a parent to Josh.
Mr. Apollos.
Mr. Apollos.
Yes.
We're just dealing with
Yes.
Mr. Apollos.
Yes.
We have to look at his moral blameworthiness when we determine sentence. Now, yes, you've referred me to Ayuk. Ayuk's facts are very different.
Indeed, my Lord.
Very different. Ayuk also, despite the fact that he played games during his trial, as Mr. Apollos did here, showed remorse. He had a total turnaround whilst he was in prison. And there were the psychologist reports and everything that was presented. And there was also a very different set of circumstances that led to the commission of the crime. He still got 10 years, and there were many charges, so it mounted up. Then, on his version, because you say I was dealing with that, he knows that she's going to be sold. He positively participates in it. Then he hides the truth. If he had, for example, come and said, well, you know, I was under the influence of Miss Smith, and I was using drugs on the day, as he told the social worker, and yes, you know, I had no other choice, or whatever excuse he wanted to come up with. He didn't use that opportunity.
Yeah.
He showed no remorse.
Yes, my Lord. Yeah. I cannot argue against that, my
He
Lord.
still doesn't show remorse.
Indeed, my lord, I can't argue against that.
Of course, I must be careful not to place too much emphasis on it because accused persons or convicted persons might argue that I'm not going to say anything now because I want to take my chances in appeal, which is the good right of any individual to do. We heard this morning of the impact it has on society.
Yes, my lord, I was moved myself. It's in a very emotional setup. From my observation, I think Mr. Pollis was moved as well.
I'm not so sure of that. I was watching it. I was watching it.
Yeah.
I don't know whether you noticed that I did that.
Yes, I only saw.
I was observing the public gallery. And I was observing the three accused. I'll get to Mr. Van Rijn and he stares at me later.
Yeah. My observation was made when they came out now before we resumed now. That I couldn't see behind me, but I wonder if the presence of the three accused in the holding area maybe had an influence. It's my humble submission that I seem to have noticed something, but I'm just placing it there.
How do I measure any indication of potential remorse? Because remember, and there are a lot of authorities to it when it deals with remorse, of where it is focused. Is it self-centered? I know I'm facing a long sentence, I'm feeling sorry for myself. Or is the remorse focused towards the victim? If it's an individual victim, in this case, it seems the whole community of victims.
Indeed, my lord.
Is there any indication of remorse being shown for the harm done? And in this case, the harm that's still continuing to be done. I referred in the judgment on the merits of the manner of reference to Joshlin, Deacon. Heartless on the face of it. How do I deal with that?
My lord, all I can answer or submit in that respect is I would plead that one must bear in mind, as was also referred to in Mr. Peterson's report, in paragraph 10, where he says he had dropped out of school early, he was never troublesome, had in fact engaged in a club rugby and conducted himself with social accepted norms. That was not what I wanted to refer to. There was a sentence here where Mr. Peterson referred to the area. And I think, yes, it's under paragraph 5, housing and environment. The second paragraph from the bottom on page 3 of my version.
No, we can go there.
In paragraph 5, there is a paragraph that starts, there is a residential area where the offender resides with his family.
He comes from a good home.
Yeah.
And yes, he grew up in that area, and we find the same comment It's the second paragraph under
Paragraph
item
5.
5.
Yes. Where it refers to suffers under this cause of social evils, which includes unplanned pregnancy, social ineptitudes, that I want to present as when, and I must be careful how I state this, my Lord. Some people do not have the language eloquence and might sometimes refer to the kind, and some social groups might find it insensitive, whereas some individuals might refer to the kind not in a derogatory or a unemotional way.
But in the context of when it was said and how it was said, would one not have expected a parent to use different terminology? It's objectifying Joshlin even at the time of the trial. And we're discussing this in the context of remorse.
I'm in agreement with your Lordship. I just would respectfully add that it must be borne in mind that the witness, when he was spoken to and questioned and cross-examined, that the stress levels were exceptionally high, which I'm not a psychologist, would suggest that it might be an explanation, and it cannot per se shouldn't per se be seen as derogatory or distantiating himself from any emotions towards the victim, Joshlin. As your Lordship has also become aware of, in the representation of this Exhibit SS probation report, there's now a difference between what Mr. Peterson says that Mr. Pollis told him and what Mr. Pollis says. And also when he mentioned that he had read this to Mr. Pollis yesterday morning, before we started, and Mr. Pollis didn't point out anything to him that he didn't agree with. My only submission in that regard would be that the stress levels are high, my Lord. I think it can be expected and assumed and accepted that the stress levels are high, and there's an idling mode, or not an idling mode, there's a high revving mode in the mind, and one maybe don't get the kind of detailed reaction as what would normally be obtained from somebody that was in a calm mode.
I find it strange, but also interesting. I've observed Mr. Pollis, and his demeanor in the court was different to Mr. Van Rynen's. So, always seemed to be nervous and very reserved, withdrawn sometimes in the courtroom. You will recall in the trial within a trial, on the day that Ms. Smith had to go for a medical procedure,
I was going to refer that to
his
that.
demeanor was very different.
Yeah.
Very different.
Yeah.
On the stand.
Yeah. I recall that.
That was also the day when he conceded under oath the discussion that took place on the 18th. Now remember, I've heard the evidence of Mr. Peterson discussing all three. he now calls them offenders. And the influence maybe of Ms. Smith on him. So when he's in Malmesbury prison on the weekend, and he has this interview with Mr. Peterson. Because what is now suggested on behalf of your client and Mr. Van Rijn is Mr. Peterson sucked this out of his thumb. He made up a story. They're not coming to gainsay it. And then he tells Mr. Peterson things. Mr. Peterson comes here yesterday morning, and remember I asked for these signatures. I asked for those pages to be copied. He confirms. Then he gets in the witness ear in the courtroom. Now all three are there. And then he flips. You want me to find that this is somebody that's remorseful? Or it was merely the revs that went up? Or the heat that was more? It's a question that I have to consider.
I understand, my lord. I did not, on behalf of accused one, cross-examine Mr. Peterson. It was not my instructions to do that. I was...
But he now says Mr. Peterson has it wrong. He never said that
it was,
to Mr. Peterson.
It was just the factual issues about the going to school, about Joshlin. And then the difference is that Mr. Peterson said that Mr. Pollis told him that, and that's why he wrote it down there. Now, I just wanted to point that out, that I find it hard to believe. I cannot say that Mr. Peterson was lying.
But you see, if Mr. Pollis didn't say that to him, then he made it up.
My lord, I respectfully want to suggest another possibility, and that's a misunderstanding or miscommunication between the two of them. We know Mr. Peterson was under pressure. My submission is that Mr. Pollis has been all along, from Exhibit MM, saying, or his version was that Joshlin didn't go to school that day.
And he was flip-flopping on why she didn't go to school.
There was a few variants about why she didn't go to school, yes. If one look at different statements, a statement of Mr. Pollis, MM, the statement of Raquin, statement of accused 3. Yes, there were various
So the versions
reasons.
change depending on the amount of revs.
But as far as this report is concerned, the mere difference, or the mere fact that I wanted to point out, is that it can only be attributed to a misunderstanding or an error by Mr. Peterson, because I cannot see that Mr. Pollis, for any reason, would have spoken about Joshlin going to school or not going to school all day.
So let's get closer to home. Tell me, where do I find the substantial and compelling circumstances?
My lord, that is where I was starting off when I mentioned the extracurrial statement. There is a version that the court accepted, and that is a role that Mr. Pollis played. As I've already mentioned, that he had a discussion with accused 3, that he walked with Joshlin to Makalima's house. That's the version.
And then, and she was going to be sold.
And in terms of the discussion that took place, in terms of the extracurrial statement between himself and
Remember, on his version, he fed her, and then he went to sell her. That's if I accept that version that we're arguing on now.
yeah.
Close your eyes and think about it. Where do I find, in his personal circumstances, the circumstances of the offense, on the evidence before this court, there's any any mitigating circumstances. Forget about that. It's substantial and
Compelling. If I may, my lord, I just want to go to the second version by the state. This is the one version, the one going to Makalima. The other version is with Joshlin going to the polo. That's the other version. Now, there is also evidence then from Laurentia Lombard and this court has accepted some of her evidence, but her evidence, I submit that in terms of her evidence, when she gave evidence about the discussions that she overheard, Mr. Pollis's attitude on 2 occasions, she gave evidence. Yeah.
Leave me out of this.
He distantiated himself from whatever was being discussed. Now, I submit that now we're sitting with 2 versions. He did something, and he indicated an attitude at a different time.
That's exactly why I raised the potential influence on him. But he didn't come and tell me that.
Indeed.
Even on sentence. Because when I listened to Ms. Lombard of that discussion on the Sunday, he immediately said, don't want to get involved in your nonsense.
Indeed, my lord.
Leave me out of it. But then he went along.
In the other version.
If for example, he had come and he said, remember, we're also dealing with the extracurricular statement. I was scared of Kelly. Or she had this type of influence on me. Or I didn't think straight because of the influence of the drugs. But now I'm clean. I regret what I did. It might have been a different story. Might have. I'm not saying it would have been. Saying might. But I've got nothing. All I have is, and we're just dealing with your client now, and let's accept his previous convictions is of no moment.
Yes, indeed, no.
Let's accept he lived a stable life. He had opportunities. Some people use it, some people don't. Yes, he grew up in difficult circumstances. But and I know there are people in this court that grew up in similar socioeconomic circumstances.
Yeah.
I was thinking this morning driving, because I had an invitation to speak at a function later in the year that came yesterday, and I was thinking of my primary school. Started in 1966 in Surrey. That school still has only 5 classrooms. And most of my classmates were people whose children who worked on the farm.
Yes, my
And
lord.
very few finished school.
Yes, my lord, I'm very aware of...
So, as I said, from what I heard here, it comes from a good home, a caring home. Yes, it took a wrong path.
Yes, my lord.
Understand that. It can happen to anybody. But then, Allah Mr. Peterson also, you then make choices. Turning to the 18th, he was averse to the idea, but then he made a choice of what happened on the 19th.
Yes, my lord.
I can just try and picture how callous that action of an adult is. Were you in a parental role? And his story, opportunity to bathe herself, wash her clothes, and then you look that child in the eye, and then you sell the child. How callous must a person be? Now, there may be reasons, but I don't have it.
Yes,
It's, again, a choice he made.
Indeed, my Lord, I'm in agreement with your Lordship as far as that's concerned. I can't argue against that. What I would still, with the leave of the court, just take a little bit further is still section 14 of the Act, A. The aggravating factors. A is the significance of the role of the convicted person in the trafficking process. Now this is exactly what we are talking about, Mr. Pollis's role. Now, I'm in a difficult position to explain that certain aspects I cannot argue. I also act on instructions, my Lord.
No, I understand that.
And that pertains to what your Lordship has referred to on that Friday when the evidence was led and the Monday when the evidence was led. There was a difference. In that respect, I'm not free to argue those effects on Mr. Pollis. But I do want to argue and persist with looking at his role. Yes, he made a mistake. He was spoken to. He did take a choice, made a choice. He was told to do this. That's the evidence. And he did it.
Keith, can I take you one step back?
Yes,
You
Lord.
referred me to Ayuk.
Yes.
And what's interesting there, in dealing with the act itself, so the judge listed, say, it wasn't this, it wasn't that, it wasn't this, it wasn't that. And it takes into account reports and so forth. But it's also tight, and it's mentioned in that judgment that you referred me to. That sentencing is the discretion of the trial court,
Yes, indeed.
because you're still in the atmosphere of the trial. So you might have instructions or not have instructions to argue in a particular way, and the prosecutor will argue in a different way. But I can take into account my observations and my understanding of the case.
Yes, my Lord. That was what was referred to in the Abib matter. Statements Abib specifically referred to Malchus, where it says that Malchus, it was said that sentencing is a lonely and onerous task. The imposition of sentence is the prerogative of the trial court. And I am at Eden with that. I understand that for that little bit that I've been involved, because the court has had and heard, seen appearances, attitudes, eyes, words, and that is exactly, yes, yeah. And that I'm at Eden with that. All I'm trying to do, my Lord, is trying to, and I don't want to take too much time, but I also want to just go back to then Dr. Van der Wat's report. And I know it is his report. He's an expert in these matters, but the evidence was heard by this court, and this evidence will be considered by this court as to how it should be, how much weight it should be given. I don't have the specific reference, but in general, he spoke about this kidnapping is a pre-planned, organized act. I just want to submit something to the effect that kidnapping is a very organized business, heinous business.
He referred to it in the context of a premeditated act.
His words were, if I could just get to it where I made a note of it, he was referring to trafficking in general and then referred to this matter. His words were, paragraph 13, under the discussion on sentencing considerations, I think it is.
It's on page 18 of the report.
Yeah. What I wrote here, my lord, is the overwhelming majority of trafficking cases involve significant planning and deliberation on the part of the offenders. Now, I understand that this court has found that there was planning in this matter, in the selling of Joshlin. There was planning. There was a pre-consideration and dealings, must have been. Mr. Pollis was not part of the August 2023 evidence that was laid by Mr. Kutsia. Mr. Pollis wasn't part of that. I don't think he, at this stage, if I'm correct, at that stage he was not, I think, in accused 3's life yet.
Well, the way I understand the evidence is that Ms. Smith was unhappy with the setup that she found herself in. And that was her state of mind that she conveyed to Mr. Kutsia. And I can accept that wasn't Mr. Pollis's view at the time. Because remember, she did not only say what was going to happen. She said, then she and Mr. Pollis can live in peace. They can have a better life. That was the evidence. Ms. Smith can shake her head as much as you want to now. I can see what she's doing. That was the evidence. So I can accept that. But that also fits in with the other possibilities that we spoke of earlier.
Yes, ma'am. Yes, ma'am.
Come and tell me that.
That is indeed
That's
so, my lord.
choice in me.
That is indeed so, my lord. So, to just round off the role that was played by Mr. Pollis, my submission is that it was a very limited role, and considering the position that he was in, how he reacted, and the decision that he made.
He executed the plan.
He did what he was told to do, my lord. He did what he was told to do.
If I would speculate, and I can take it into account and elevate that to a factor, that might be a possibility, and I'm saying it might be a possibility. But that's what other words have to deal with facts.
I just want to tie that up with that decision that was made, as the Lordship had said, a decision he made. And as I submit, a messenger kind of transporter kind of role, that was in a state of being intoxicated with drugs. Whether that's going to affect his blameworthiness, I can't argue that, but I think in practical terms one must bear in mind at that stage he was not a right logical thinking, not in a right logical thinking mind. I think that can be sufficiently assumed and accepted.
Now let's accept that for a moment. Let's accept, because we know from Ms. Lombard's evidence, and that's common cause,
Yes.
that the three of them, and then Ms. Lombard as the fourth individual, were consuming copious amounts of methamphetamine and other stuff as well, over a prolonged period, but specifically that Sunday and the Monday. Let's accept that they were affected by these substances. Let's accept then that in that state of an altered mindset, the act is performed. Now dealing with the crime. But then, that evening still, Mr. Van Ryn and Mr. Polis, they go and have their further drug binging. Let's accept that. So that's the Monday evening. Tuesday morning, the reality strikes. What do they do? They actually frustrate the possibility of Joshlin being found. Now let's accept then that this altered state of mind, chemically induced, lessens the blameworthiness on the 19th. What does the actions post the 19th do? Doesn't it increase the moral blameworthiness? Or do you keep on that level of pain? And looking at it holistically then, does it not balance each other out? And then you look now, we're sitting, what's today? 28th of May, 2025, more than a year later. Still had the opportunity until now, this morning, to come and tell me this. Joshlin is still missing. And they still throwing the lines on the wrong side of the boat. We'll be discussing moral blameworthiness.
Yes, ma'am.
I'm now going to leave you alone so that you...
I cannot take that any further, my lord. One of my headings was drugs. We've dealt with that now. The drugs added a role to play. Whether that affects the blameworthiness, I can't argue that, my lord. There's one other, and I am mindful of the fact that in case law, and I think it is also mentioned in the Ayub matter by the Acting Justice Debate, when she says there can be no prospects, or she finds it difficult to accept that there are prospects for rehabilitation if there is no remorse. I'm mentioning that, my Lord, because I want to argue that that in the Ayub case in paragraph 48, page 12 of the copy that I have.
Paragraph 48.
Paragraph 48, my Lord. If I may read it, it starts, it says, it was submitted on behalf of the accused that they could be rehabilitated even though they have not admitted to their crimes. And the next sentence is, this is difficult to understand as rehabilitation is not possible without a person accepting responsibility. I'm just mentioning that because it's my duty to place everything before the court. But I want to argue that, or submit that I respectfully disagree with that statement that it is that rehabilitation is not possible without a person accepting responsibility. My Lord, remorse, to become sorry for what you did. There is no definite time period where it sets in, I submit. Some people may never show remorse, and that might be a psychological thing. Other people take longer time.
I don't know whether, I don't know the context, because she's referring to a submission made
Yes.
by counsel.
Yes.
So I don't know what the context of the submission is, but as a matter of logic, it could also be on a timeline.
Yeah.
So at trial or at sentence, there can be a lack of remorse, but that remorse might kick in
Yes.
on day one of the sentence or 20 years down the line.
Indeed, my Lord.
And it might be focused at a particular point,
Yes,
in a different direction, and then you might have somebody rehabilitated.
Yes, my Lord.
Now, that's of course always possible to my mind, and that is why we have a system of parole. So
Yes.
when a person gets life imprisonment, the process is after serving a minimum of 25 years, the person will then go through the processes. And you see when we used to have the referrals back, remember with the old, the dangerous the criminals, those people come back to court. I've actually dealt with one or two where it's more than 20 years after the sentence, and then you see the reports on the individual and their conduct in prison. So that's possible, but how do you measure that at the stage of sentence? And I've indicated to you that the lack of remorse or remorse is not the primary factor here, because it needs to be balanced.
Yes.
You need to take it into account with everything. And I'm well aware that I shouldn't overemphasize it, because in a case like this, where the accused persons might believe that I still have a chance of appeal. I'm not going to say anything now.
Well, that will be a gamble, my lord, anyway.
So you shouldn't just say because of that. One need to balance these factors, all 3 or 4 of them, and any other factor that might be there.
Yes, my lord, that's, we are all aware, I don't have it in front of me open now, that there might not be one specific factor that amounts to substantial compelling evidence factor, but if there are a few aspects or factors joined together, one might get to a point where the court feels that there are some compelling and
But there are also authorities that indicate that in certain cases, in certain types of cases, and certain offences, that some of the factors to be taken into account will have less weight in this balancing exercise. And there's the old Afrikaans expression from a case that says dat gepaste omstandighede moet die persoonlike omstandighede van die beskuldigde wyk voor die belange van die gemeenskap.
yeah.
To translate that in appropriate circumstances.
Yes, my lord.
Personal circumstances, and I want to read in other factors should have less weight than the interests of society. And what is Dr. van der Walt? Some of the opinions he expressed from the information that he has on the studies done and research done is the interest of society in these crimes, these types of crimes. And in thinking about it, and I'm going to reflect a lot more during the next number of hours until tomorrow morning. In the case where a child is the victim, the primary victim, one has to go back to the values of us as a people. And that's protecting not only human dignity, but protecting the vulnerable in our society. And then we read that with section 28, so I'm looking at the preamble of the Constitution on page 28. And then we heed the warnings that our courts have expressed on how we should approach the matters where the interest of children in particular and vulnerable societies and members of that society in general comes into play. And it's not easy, and it won't be easy for me until tomorrow morning. Because it's factors I need to take into account. And ultimately I have to remember and never forget that human beings are fallible, and I have 3 fallible human beings in front of me. And their lives are literally in my hands.
Indeed, my lord. Yeah. I mean, we're all very familiar with the gravity of the offence, the circumstances of the offender, and the public interest. Yeah, that's the balance that your lordship needs to find there. To just round off the aspect of rehabilitation. I'm just submitting to your Lordship. It's an aspect that should really be considered. And I want to stress and just again bring it under your Lordship's, under the Court's attention that in Mr. Peterson's report, Mr. Apollos is described as a quiet, reserved character. When one has, and I submit this with respect and humility, there are different, if one can do that, grades of criminals. You have your callous criminal, cold-hearted, in character, in mind, and in actions. Yes, the actions, what took place here, where Mr. Apollos is involved, yes, that is a heinous crime. It is very serious, involves a child. But I just want to submit that one must not, it needs to be borne in mind that considering from the Zin triad, his personal circumstances, that he is not this or a callous, cold-hearted.
What were the facts in Zin?
Sorry,
What were the facts in Zin?
well, I can't remember that. I really cannot
You know
remember.
how old,
It's
what
very-
the age was of?
It's very old, my lord.
No, but do you know? No, it's an old case. But do you know what the age was of the accused?
I can't recall it, my lord. My memory is not that good anymore.
No, it's not a question of memory. It's a question of counsel referring me to cases and not knowing the facts.
I'm referring to your lordship to
I
a...
cautioned you about that.
Yeah, no, I'm referring to your lordship to a principle which is referred to as the triad of Zin. I'm not specifically referring your lordship to the Zin matter. I'm referring just to the principle of the triad of Zin.
And the same applies. The same applies to Rabi. These are the two cases that illustrates either the triad and then coupled with the element of mercy. If mercy is an element. Because remember I referred to the three judgments. In both of those cases, the accused person was an elderly person. And the type of offenses were not what we're dealing with here. But over the years, I've been constantly referred to Zin and Rabi. In fact, I argued them myself when I was an advocate.
Yeah. I'm just, for the sake of completeness, we all know, and I mean, I think it's right that there are the balancing, that there is this balancing act. And I can take the matter no further, my lord, as far as the possibility for any mitigating factors is concerned. I want to just address your lordship on one last aspect, and that is count 2 is kidnapping. I just have one. I know when it comes to sentencing, usually sentences run concurrently, unless it's specifically stated that that doesn't run concurrently. But I think when there's a possibility of a life sentence and another sentence, it is bound to run concurrently.
If I impose life imprisonment on count 1, I need not say anything about the concurrency on
Yes.
count 2,
Yes.
because by operation of law,
Yes.
it will be served
Yes.
concurrently.
Indeed.
If I ever deviate and impose a lesser sentence on count 1, the parties need not address me on concurrency because I'm of the view of the connectedness between the two, that the sentences should be served concurrently. So you need not.
Yeah, thank you. Thank you, my lord. I was going to refer to S versus Young, but I didn't. Yeah. It's not as your lordship says. Yeah. My lord,
It's because that's where the problem often lies as a matter of interpretation, because it's a duplication of punishment, and then it gets elevated to a duplication of charges, and a big hullabaloo is made about that. But here, the kidnapping was an integral part of count one.
your lordship. Thank you, my lord.
It must run concurrently.
Yeah. My lord, then, unless your lordship want to hear me on anything else, I'm not going to deal any further with the penalties, section 13, other than just, as I started off with saying, your lordship need to, I can't find any case law on it. I cannot take it any further other than to submit that there might be some consideration to be given, as I've already read, paragraph 30, section 13 of the Act, where it says, including imprisonment for life. I would respectfully submit that maybe there's a difference in that it doesn't dictate that life should be given. It is an option. And then to just conclude, all of this to be viewed that Mr. Pollis is effectively a first offender. His previous conviction was one a petty theft thing, with I think it was 1,000 rand fine or something, but it was a petty theft.
No, I'm with you.
Yeah. So if there's nothing else, your lordship.
No, thank you.
Thank you.
Thank you, Mr. Kabai.
Must go in front. Thank you, my lord. It is correct that my client, Mr. Van Rijn, has been convicted of a very serious offense. It is further correct that he has maintained his innocence until this minute. I would like to argue my case from that angle. I have furnished the court with my authorities, but sadly, most of them, they refuse to download from my system.
No, I've opened many of them. And as we go along, I will open more. So don't be concerned about that. I'll give you the list in a moment. You've given me Zin, Rabi, Mutanti. Some of these references are references that I found the cases under the different reference. Banda, Mokoena, Smith, M, the Constitutional Court case in M, Mafu, Mlonyeni, Masota, and Tula. That was the 11 that you sent me.
There is a second list, my lord.
What second list that came
I
with?
sent in the morning. It was 4:30, 4:15.
This was the list that was sent
It
at
was
6:34 this morning.
Marcus Machichi.
No. I also have open on my screen Malchas, Machichi, Habib, Ayuk, and others.
I forgot.
So if you sent everything that you sent, I've actually looked at. There were two sent this morning. But don't worry, if you want to refer to a case and I don't have it open, I can open it quickly.
Okay.
I've got access
Okay.
to everything here.
It is true that my client maintained his innocence from the start of the case up until this minute. I would submit before this honorable court that my client's silence or his denial of guilt may not be taken as an aggravating factor on the following grounds. My client didn't exhibit or is not exhibiting any chance or any opportunity of re-offending. My client is open to rehabilitation. Although he has maintained his innocence, we respectfully submit that alone should not prevent this honorable court from giving due weight to his personal circumstances. They appear in the report that was filed by Mr. Peterson yesterday, but I wish to add the following. When the alleged offense was committed, my client was 27 years of age. My client today is 28 years of age. My client is a father to a 4-year-old daughter by the name of Hope.
Is she currently 4 years old? I saw it in the report.
Yes,
She's currently 4 years.
yes. My further submission, my lord, will be his stance on innocence must not at any manner diminish the fact that my client has suffered from the day he was arrested, including to date. I'm not going to go to the manner in which she suffered. The manner in which she suffered is before this honorable court. I'll go, my lord, I'll refer to the case of State versus Banda. State versus Banda.
Banda.
This matter didn't download from my system, so I won't be having the facts of the matter.
So did
But
you not-
I'm having the principle.
Did you not read the case?
My lord?
Did you not read the case?
No, I didn't. The whole case, my lord.
So how do we know that it's relevant?
You will know that it is relevant from the principle, my lord. State versus Banda, 1991, volume 2, SA.
Just one moment, I just want to find it.
Oh, sorry, my lord.
Banda. No, 1991. So where did you find the case?
My lord?
So where did you find the case?
Yes, can I proceed, my lord?
Remember there were few cases of Banda around that time.
Let me leave it, my lord. If it's like that, I'll leave it.
No, if you want to refer me to the case, you've got to give me the facts. And I'll tell you why I'm asking you. Because there were a few Banda cases
That is the reason I'm saying I'm leaving it. my
during
lord.
that period. And do you know where it was decided?
Pope Tatswana,
Yeah.
my lord.
And what was it about?
I told the court, when I was reading the facts of the matter, my system couldn't download
But where
this
did you
matter.
get the facts?
My lord?
Where did you get the facts of that case?
When or where?
Where? Because you're telling me you read the facts. Where did you get it? That case has been referred to in a number of cases.
I got this from my old notes, my Lord. My old references. In my old references, I didn't write the facts of the cases. It was only the principles. Now when I notice that I don't have the facts in my old references, I try to download these cases, but in vain.
What part of the case do you want to refer to? Where Friedman J. made reference to the triad. In one of the Banda cases,
Yes.
in that 1991 2 case, it was presided over by Friedman J. As he then was. He was later on Friedman JP in the case.
Okay.
And it dealt with the potential overthrow of the government of Bophuthatswana at the time. And so far as it relates to sentence, he referred to the triad of circumstances. It was also quoted in the Constitutional Court in M versus Child Law. How does it help us? That's why I'm asking you, what is the principle you want to refer to? How does it help us here?
It will help us here, my Lord, in the principle of innocence, in the principle of the accused person remaining silent.
I'm listening.
In this matter, the court held that even if the accused maintains innocence, mitigating factors can and should be considered to avoid an unduly harsh sentence. I've mentioned above the mitigating factors.
I'm listening.
The
listening.
mitigating factors in this matter pertaining my client's personal circumstances, my Lord.
Yeah.
It is my submission further that the denial of guilt does not preclude finding of rehabilitation potential, especially that my client previously was convicted and he has shown a sense or a measure of self-rehabilitating himself. It is my humble submission, therefore, that this court must not consider his silence as being lack of remorse. He is willing to reform, my Lord, even though he's still insisting on his innocence, but he's willing to reform. At his age, to reform won't be a challenge. That is something that he's looking up to reform and to rehabilitate. Further to these aspects of him insisting on his innocence, insisting on innocence, my Lord, is a right. And it cannot be referred to as someone who's showing a bad character before court. Is exercising his right and cannot on its own be inferred as a lack of remorse on his part. An accused person, my Lord, can still receive a lenient sentence, and his mitigating factors can still be considered even when he elects to maintain his innocence. Further, my Lord, it is true that my client has previous convictions. Now we need to look at the period when the first conviction was imposed upon the person of my client. It was the year 2014, and the last conviction, my Lord, was in the year 2020. I would submit, my Lord, that each and every case has to be individualized when the court want to determine a just and a proper sentence. Humble request this court not to look at the past of my client when determining a just and an appropriate sentence. My client was a youth at that time, and he was abusing substance. Humble request this court to take that into account when considering a proper and a just sentence. Humble request that the sentence process must still be fair and constitutional and not unduly punitive, simply because the accused person has previous convictions or that he has maintained his innocence. That will help the court, that will help prevent the court from penalizing the accused solely for maintaining his innocence and for his previous convictions. My Lord,
I'm listening.
I will humble request refer this court to the matter of State versus Makiti.
Yeah.
I'm making reference to this matter regarding substantial and compelling circumstances. My learned colleague has listed this matter as the matter she will consider when arguing in sentence. I would like this court to go to the very first paragraph of this case. I will read it for the court, my lord. In the case of State versus Machichi, 2011-1, SACR 40
No, that's not the first paragraph of the case. A case will not start if it's Machichi to say in the case of Machichi. Which paragraph of Machichi do you want to refer to? We're looking at the SCA case.
Without making reference to the case, my lord, I know which part I want to refer to in this matter.
No, in Machichi, you took me to Machichi, so
Yes, it's still in Machichi, my
tell
lord.
me about Machichi.
I'm still in Machichi, my lord.
Okay, what are the facts? What were the facts in Machichi?
The crimes took place in two separate incidents.
Yeah, but what were the crimes and how were they committed?
I'm
Because
going
remember,
there, my
we're dealing with sentence here.
I'm going there, my lord.
Okay, so tell me the
Separate
facts.
incidents separated by 5 days. In the first incident, the respondent was one of a gang of 3 who attacked and robbed the complainant. In brackets, the complainant in this paragraph is Mr. AC. Mr. AC has been sitting in his car at the beach.
Well, his name actually appears in the judgment. You're reading from a summary.
Yes, my lord.
You're not reading from the case. Did you read the case itself? I caution counsel, and I'm repeating myself a number of times during the course of this case. If you want to quote a case to me, I want to know that it's relevant to the issue that we're arguing, and to know that we need to know what the ratio dicadendi is, and to determine that you need to know what the facts and the issues are. So I can tell you, the complainant in the first instance, right, his name was Anthony Cannon, and he was 45 years old. Because that's how the first paragraph of the judgment of the Supreme Court of Appeal starts. And then his car window got smashed in. And a wood was pulled over his head, and he was taken and he was tied to a tree, and his bank cards were taken, and they couldn't access these bank cards, and so on. And then his Honda Ballade was found. And then on another date, after the car was found, and he was then missing his JVC radio player that was taken from the car. That's when the persons with the initials KD and MF was abducted, and that's when the rapes and so forth took place.
Those are the same facts of the summary, my lord.
I don't want to talk about summaries. I want to talk about the case. But take me to the paragraph in the case that you say is relevant to our matter. Then we can go there. I've got it open in front of me. Which paragraph of Machichi do you want to refer to?
My lord, I want to refer to the facts of this case.
No, take me to the law point you want me to.
Thank you, my lord.
Machichi.
The law point I want to take this court to is,
Which,
in this matter,
which paragraph of Machichi? Which paragraph? The case is in the new style with paragraph numbers. So which paragraph number of Machichi
my lord,
do you want to refer me to?
when I was preparing my address in sentence, I used the summary. I didn't use the case. If the court wants me to refer it to the paragraph, I will humble request an adjournment. So
No,
that
you're not going to get it because you gave me that case on your list. Remember, you first sent me 2 cases. That was the 4 o'clock email this morning. And then there was another email that was sent at 6:34. Or it was forwarded to me at 6:34 by my registrar. By then, I was already on my way here.
with due respect, my lord,
And I'm talking about the long list, ending with the Constitutional Court case of Talu. So when I got here this morning, I started reading those cases. But Machichi is a well-known case. It's often referred to. Remember, it followed that whole long saga with Nkomo and that culminated in this judgment, and then there was also Chabalala and others dealing with the minimum sentences, if one can call it that, and then how to look at substantial and compelling circumstances having regard to the locus classicus of Mare J.A. in Malgas, because that was the first one in 2001. So, I've read the case and I'm going to have a look at it again tonight. So, carry on, skip the point.
my lord, the point I want to highlight in this case of Machichi is as follows. in the case of Machichi, there was a victim. A victim was called to court and the victim testified. In this matter that we're having before this court, we don't know the whereabouts of the victim. We don't know whether the victim has suffered any physical or psychological injuries. Yes, the community, through the voice of the social worker, has testified, but that is the community, is not the victim herself. Why I'm raising this point is because in the matter of Machichi, which my learned colleague has made reference to, in that matter, it is highlighted that when the judge is imposing a sentence, the victim-centered approach is very important. So this matter, my Lord, I humbly submit that it is very irrelevant to the matter that is before court. The matter of Machichi, and on those two incidents, the complainants testified in court. They could testify to the injuries they have suffered. In this matter, there's no victim who could testify how she suffered, if indeed she suffered. That is the point I wanted to raise.
The state raised Machichi for a different reason. And with reference to Malgas as well. And the reason, and I'm reading in, is because what the Judge Akwo did in Machichi, he deviated from the prescribed minimum sentences. And this is not my view, I'm using the words of Marie J.A. in Malgas. Because he cautioned, the Supreme Court of Appeal cautioned in Malgas that these specified sentences should not be deviated from lightly or for flimsy reasons that you cannot defend. And I'm paraphrasing, I'm just using the flimsy and lightly from the words of Malgas. So you shouldn't look for reasons. And of course that goes back to Rabi with reference to foot in the Pandectus as to how judges should look at sentences. And that was the underlying common law approach which found its way into Zin. So in the judgment of Corbett in Rabi, he actually quotes the old Roman and Roman Dutch authorities from the Latin. And then also say you mustn't have anger, you mustn't be too harsh, but you mustn't have maudlin sympathy.
I agree with the court, my lord, but I'm still on my first point. First emphasis. that was mentioned in this matter of Machichi. First emphasis that was made in
Don't forget about the differences in the facts. Machichi is not a case to be used in mitigation. Machichi is a case that deals with aggravation, and so Machichi is not applicable to mitigation. But you don't have to refer me to Machichi. I've read Machichi. In fact, I have it open in front of me here. When I look to my right, I'm looking at the judgment. So carry on, skip Machichi.
even if I still have some points in Machichi, my lord.
No, you don't have to refer me to Machichi further. The facts are very different, and the circumstances there were. These were armed robbers, kidnappers, because remember the person was taken to the wood and tied to the tree, and rapists. It's not applicable to your client.
Not applicable even in this case, my lord.
I'm sorry?
Not applicable even in this case of Joshlin, my lord.
It's not applicable to be applied for mitigation in respect of Mr. Van Ryn. And the principle is tried by now.
The other matter that my learned colleague made reference to is the case of Van Wenzel.
Of, which one?
Let me check the right. Where's this one? Just a minute, my lord. I will turn it somewhere. Ivan Wenzel.
The case of? I've got Ayuk.
I want to check the full citation, my lord.
Just give me the name of the case, then I can find it.
Ivan Wenzel and the state.
Ivan? What? Yeah.
It's Wenzel, W-E-N-T-Z-E-L, and the state.
Okay. Just spell that name again.
W-E
W-U-E
N-T
N-T
Z-E-L.
Z
Z-E-L.
E-L.
Yes.
Is it Wu Hensel or Wenzel?
In the cases that I sent to the registrar, I actually sent the judgment itself. It was an attached judgment. It's actually Ivan Wenzel. I-V-A-N-W-E-N-T-Z-E-L. It will not reflect as such on SAFLI because of the fact that the names are redacted. So on SAFLI it is reported as C and W.
C and W versus the state.
Versus the state, indeed, my lord. Case number A301, 2024, it's a reportable judgment.
I must have missed it on the emails that was. When was it sent?
Yesterday, my lord.
Was it attached? So was it sent to me yesterday? No, got it. This judgment was given last week.
Indeed, my lord. That's why I'm saying it's a very recent judgment. It was delivered on the 13th of May, 2025.
Okay, I've got the judgment open. You can take it.
Thank you, my lord. Further to this case, my lord, it is my humble submission that this matter is irrelevant regarding the matter we're dealing with. In this matter, the complainant appeared in court, the complainant testified, and we could testify to her injuries. Charges were rape. In this matter, we don't have the victim. We don't know whether she received the injuries. We don't know where she is as we speak. The matter that was quoted by my learned colleague, I humbly submit that this is relevant in this matter.
Yeah.
The other case she made reference to is State versus Ajuk.
Yes, I've got that one open as well.
Accused person in this matter faced 28 counts, ranging from human trafficking. Complainants in that matter testified in court. They could testify to their experiences. They could testify to their injuries. In our case, we don't have a complainant who came to testify. We don't know the injuries. We don't know whether she suffered injuries. We don't know the surrounding circumstances of her being trafficked or exploited. I humbly submit that even this case is irrelevant in this case.
Yeah.
Now, my lord, I want to argue the probation officer's report. At the court, I requested the probation officer to compile the report. It took only 3 weeks, or about 3 weeks, to be finalized. Mr. Peterson, who testified yesterday, didn't give consideration to the mitigating factors of my client. He was too focused with the aggravating factors in this matter. And his role is to prepare a report that is complete and balanced to assist the court to reach to a just and an appropriate sentence. He failed to do so. Mr. Peterson was very biased before this court. Other than giving recommendations, he gave orders. And as a result, I have to ask him whether he was a judge.
Because he showed the same biases as the judge.
I don't know about that. I'm speaking about Mr. Peterson, my lord.
Oh. No, I just wanted to know. Because that's what your client told you.
My lord?
Didn't you hear?
No, I didn't.
I mentioned it to you because that's what your client told him.
My client,
So there is now a further person who must be blamed. He blamed everybody, including myself, for his dilemma. And now we must blame Mr. Peterson as well. But carry on.
I'm not blaming him, my lord. I'm arguing my case.
Yeah.
This is how I saw him.
Yeah. You're entitled to your view.
Further, my lord, he was very evasive. When I asked him, where did you get the information when he prepared his report? He was not clear whether he got some from the media. When I asked him, he said, no, not entirely, not complete. From there, he got summaries of the case. We were never asked to furnish the probation officers with our evidence. No heads of arguments for that matter. For
Ms. Nkabai, I have to stop you. I was being patient by not interrupting you, but I'm not going to allow you to make submissions that is untrue. And I'll tell you why.
Yes, my lord.
You will recall at the appearance of the 9th of May, and it's on record, I indicated that I have prepared the drafts of the letters for the probation officers. And I invited everyone to give whatever information they wanted to be considered, including yourself. Now you say you were not invited to provide information. It was free to you. In fact, we held back on sending off the letters until you had an opportunity to add anything to be considered. And I'm aware that there were inputs made and names of people. That is why when I walked into court that morning, where you were present, as well as the other counsel for the state and the defense, after the parties had been in my chambers that morning, but I will only deal with what happened in open court. So, if you make a submission, make sure it's factually correct, because the submission is made here whilst the record of this case will reflect what happened on the 9th of May in Court 1 in Cape Town. Now we're back in Court 1. When we were at the 174 stage, I spoke about Court 1 where the state versus Beta was heard. Yes.
My lord, this question was put to the witness yesterday.
I'm not challenging you on the question, I'm challenging you on the submission you made that were incorrect.
Mr. Peterson made it clear before this court that there are no mitigating factors as far as my client is concerned. Mr. Peterson showed a strange demeanor before this court when I was cross-examining him. When he was giving answers to my client, he continuously pointing at him when he was giving answers. He was also overly confident when he was giving his orders. I hand review his report as not being biased. Coming to the report by Dr. van der Walt. Yes. Dr. van der Walt confirmed that he only received heads of arguments from the prosecution side. I will humbly submit that his report also is biased. I've mentioned that. My arguments were solely based on Makiki, and the court has told me not to make any reference to Makiki.
Yes.
Coming now to the punishment itself, my lord. When this honorable court is considering a sentence, we humbly submit that punishment should befit the criminal as well as the crime, be fair to the society, and be blended with a measure of mercy according to the circumstances, while solely selling his microwave. I would submit that he might have been at the wrong place at the wrong time. It is understandable, my lord, and it is trite law that plainly any sentence imposed must have deterrent and retributive force. But of course, one must not sacrifice an accused person on the altar of deterrence. A sentence blended with a measure of mercy, we humbly submit that it won't sacrifice our client on the altar of deterrence. While deterrence and retribution are legitimate elements of punishment, they are not only ones, or for that matter, even the overriding ones. There are other factors this court must take into account. And this court must not penalize my client because of insisting on his innocence or because that he has a previous conviction. Each matter is decided on its own merits. It is true that it is in the interest of justice that crime should be punished. However, punishment that is excessive serves neither the interest of justice nor those of the society. If this court today can impose a severe sentence, I doubt the interest of justice will be served by that. I doubt the interest of the society will be served by that. there had to be a balance. Balance taking into account that on the day in question, my client was only selling his microwave. There's a commentary I would like to refer this court to.
Yes.
It is by Foot, F-O-E-T. I would like to give this court the article.
Commentary.
V-O-E-T. On the Panditis, P-A.
I doubt that we'll find food
It's in,
on the internet. VOET. And what
Yes,
is
my
the
lord.
reference?
Panditis, you open the brackets 5.
5.1.57.
That's
Close bracket. We won't find it on the internet. And I doubt that you've read it. I doubt that you've read it because you wouldn't have been able to find it here.
Okay.
There is a translated version, but it's written in Latin. And that one I referred you to is in the commentary at Pandecta. And you found it in a textbook, didn't you? Or somewhere.
Yes, my lord. It's just one sentence.
And you know where that person found it, that reference. Because very few of the sources exist. One of the places where the commentary actually can be found is in our library in Cape Town in the High Court. But nobody looks at it. You see, I told you, please don't refer me to a reference if you haven't read it. Because it's selectively quoted. But the easiest way to find it is to a case that you did refer me to. Remember I explained earlier that Corbett J.A. had gone back to the original common law sources when he discussed in Rabi how a court should approach a sentence from a sentencing perspective. Now, it's not because I'm clever. It's because I actually read Rabi this morning, early morning. I know you were awake because you sent emails that time of the morning. I read it this morning and it stuck in my head.
And this comment, my lord, was made in the case of State versus Rabi.
It was made in Rabi. It was made in Rabi, and in Rabi itself. So Rabi goes back and refers to certain selections of the writings of Foot that was in Gaines, the translation, volume 2, page 72, where he refers to the writings of Cicero in the Roman Empire. And the comment is, this is now a quote from Gaines' translation of Foot. And it's quoted to read, "It is true, as Cicero says in his work on duties, Book 1, Chapter 25, that anger should be especially kept down in punishing, because he who comes to punishment in wrath will never hold that middle course which lies between the too much and the too little. It is true also that it would be desirable that they who hold the office of judges should be like the laws, which approach punishment not in a spirit of anger, but in one of equity." This is Corbett J.A., later to become Corbett C.J., referring to Gaines' translation of Foot, where he previously referred to the section that I referred to you earlier out of the commentary on the Pandecta. And he goes on and he deals with Van der Lingen and those ones that we learned about in Roman law, when Roman law was still a requirement for an LLB, many, many years ago.
Thank you, my Lord. In this matter of robbery, Foot comments that there's a need for judges when imposing sentence.
Can I just
Not to be.
Can I just mention to you, it's an important reminder to any person that has to impose sentence of trying to be fair, trying to be just, and not to let your emotions run away with you when you're dealing with the lives of people. It's an important reminder. Yes, there are old references. I've been referred to Rabbi so many times. I myself has referred to Rabbi in judgments. I've referred to Rabbi a lot of times standing where you are standing, because it's nice to refer to that element of mercy. But for those that haven't looked at this original case recently, it's a good reminder. When I read it this morning, it reminded me of my duty. So you're on the right path by taking me there.
Okay.
Thank you. So, just in closing, so Corbett J.A. in that judgment, after dealing with all these old sources, and before he turns to discuss the 1969 case of Zinn, remember this judgment was in 1975, he says, and I quote, "Despite their antiquity, these wise remarks contain much that is relevant to contemporary circumstances." He also included a lot of other direct sayings from the old Latin. those were still the judges that could read Latin.
In conclusion, my Lord, I will argue that there are substantial and compelling circumstances present in our case to warrant the court to depart from imposing a minimum sentence. I've mentioned them, my Lord. They are paying the probation officer's report. There's no need for me to mention them again. Without being disrespectful before this court, I would like the following also to be taken as a mitigating factor. The following to be taken as a mitigating factor when court is considering a just and fair trial. In criminal cases or in our criminal justice system, it is so important, it is vital in fact, for the complainants to participate or the victims to participate in crimes. Unfortunately so, in this matter, the victim could not participate. I will humbly request the court to consider that factor as a mitigating factor in this matter. I would like to refer this court to the matter of Marcus that is in front of the court. The judge in this matter was Cobalt Jane.
Which one? To which case do you want to refer?
State versus Malchus.
Malchus. Malchus was Marais, if I remember correctly.
Not Cobalt.
Malchus was Marais. Yes, he was already a judge of appeal in 2001. It was Marais Jaya. Remember that was at the outset of the minimum sentences.
Can I give the court the full citation of this matter?
No, I have the case open here in front of me.
The Supreme Court of Appeals.
I'm not saying I know the case, but I've read it a couple of times, and I have it open in front of me. It's here. You don't have to give me the citation.
In this matter, the Supreme Court of Appeals held that ordinarily the prescribed sentence should be imposed and that the sentencing court should not deviate from the sentences for flimsy reasons. However, if the prescribed sentence would be unjust or disproportionate to the offense, then it must be departed. I've already placed before this honorable court the rare surrounding circumstances regarding the commission of the offense itself, or the rare circumstances regarding the disappearance of Joshlin, and the fact that she couldn't testify. Having said the above, I humbly submit that the prescribed sentence in the circumstances of this case would be unjust or disproportionate. Someone will argue that the issue of the age, issue of my client abusing substance, issue of him being a father and a breadwinner cannot be regarded as mitigating factors. My submission on that will be as follows. It is also wrong to view circumstances as substantial and compelling only if they are exceptional, in the sense of being seldom encountered or rare. We're not looking for rare factors. We're not looking for seldom factors. We're looking for the personal circumstances of my client. And they are what they are. And they is to be regarded as mitigating factors.
Yes.
Humbly submit that may this honorable court, when determining a just sentence in this matter, must independently apply its mind to the question of whether the prescribed sentence is applicable or not. Taking all the evidence in total.
Yes. Anything else?
Yes, my lord. I humbly submit that it will be a misdirection for a court to impose the prescribed sentence in the absence of evidence regarding the emotional impact of the complainant in this matter.
Yes.
We do not know the emotional or psychological status of the complainant. We don't even know whether she was abused or is being abused. We don't know her present well-being. To assume that she's likely abused will be a misdirection, which is highly speculative in the circumstances of this case. My lord,
Yeah.
here we cannot describe the physical and the psychological harm suffered.
Can somebody maybe just help to adjust the microphone, because there are times when I can't hear you, Ms. Nkabai, because of the wind on the shutters. It makes a noise, and I want to hear you. Thank you. Thank you.
Thank you, my lord.
covered most of the issues that one could cover. But if you have further submissions, let's get to it.
If the court can be patient with me, my lord.
I have been very patient, Mr. Kabai.
I have made a reference to the principle in the matter of State versus Zen.
State versus?
State versus Zen.
Zin.
I've mentioned the issue of
Yeah, no.
punishment being blended with mercy. Those are my submissions, my lord.
Thank you. Mr. Signarayan. Mr. Harms is looking at me as if he wants an adjournment. If I take an adjournment, I'm going to take it for 5 minutes or so, or 10 minutes. I'll tell you why. You would have realized that I have a major task ahead of me till tomorrow morning. So I want to get out of here as soon as possible. I want to conclude the arguments so that I can go and work in order for me to deliver the sentence in the morning. So, are you ready to proceed? Or you want to take a break? Don't look at him.
My lord, I do not intend being very long, but I would appreciate a break as well.
Let's take until 1 o'clock. It's 13 minutes. Then we're going to come back. And then we can hear you in the state and then finito.
Thank you, my lord.
In the meantime, we must get stuff ready to pack, Jerry. All of this going home with me. But when we're done, we need to move. And the one with, I think, section 277 roundabout there. Court adjourned.